Thank you very much. Thank you for this introduction, which sets out the major parameters of the jurisprudence concerning the access to documents. I'm sure we'll have lots to say about all that. So without further ado, I'd like to turn it over to Mr. Maes, who is one of the people in the Commission who deals the most about this whole issue. So he's clearly an expert by virtue of his immersion in this issue. So he'll be giving us the perspective also from the point of view of the Commission. May I please ask you to try and respect the
time?
quota?
Yes.
Thank you very much.
Thank you very much. I will leave a little bit here the regulation aside and try to first explain the general approach of the Commission vis-à-vis transparency. Transparency is more than access to documents. Transparency is in fact a policy which not only is reactive in saying when somebody requests access to a document, you should hand it out, but also a policy aimed at informing citizens and at consulting citizen stakeholders on new policies and on their decision making. So the purpose is to enable citizens to have an informed debate and to participate in decision making. There again, I will go back to in history to Bart Driessen started with the declaration attached to the Maastricht Treaty, which was the first text, in fact, where the right of information and the need to provide information to citizens in order to enhance the democratic nature of the institutions and the accountability of the institutions was said. This is the starting point also for a policy on information and consultation of stakeholders. The Commission started in the 90s in parallel to these rules on access to documents also to increasingly produce green and white papers before launching any new policy initiative. They started also to organize stakeholder consultations, conferences, etc. And in fact, from 2000 onwards, this policy was developed in more detail. The Commission published a paper on European governance, where it set out a number of principles for European governance, like openness, effectiveness, coherence, participation. And in 2002, the Commission also adopted a number of principles and minimum standards for stakeholder consultation. So defining that there should be a clear content in consultation, that they should target the groups that have something to say in consultation, that documents would be published, that would be given enough time for stakeholders to react, and that also there would be feedback through these consultations in the policies that would then be submitted to the legislator. So in 2005, the Commission then took an initiative called the European Transparency Initiative, where in fact it tried to settle a number of things. It tried to give more transparency on the relations between the Commission and lobby groups, because it was felt that the policies of not only the Commission but also the European Parliament was being influenced by lobby groups, and that there should be more transparency in who is lobbying whom. So the Commission decided there to create a register of lobbyists associated with a code of conduct. So lobbyists, it's a voluntary register for the moment, that is incentive based. So lobby groups registering in this register, receive advanced information of policies in the area of policy in which they are interested. That's the carrot. The stick is the code of conduct they have to subscribe to. The Commission also reviewed its standards for consultation, and also, something new, it decided to be more transparent on who receives EU funds. This has been an issue for some time, who's receiving agricultural grants or regional aids. So the Commission enacted legislation in its financial regulation and then the subsequent detailed regulations on the publication of the beneficiaries of EU funds. Either the Commission publishes itself for the so-called funds centrally managed by the Commission, it's on the Commission website, and for the so-called shared management, for example, agricultural grants, it's done by the Member States. There has been a little a development in this due to the court, again. Two German farmers and a German animal feed producer have taken the case to the court, to an administrative court in Wiesbaden, And the court then referred this to the Court of Justice and a so-called preliminary ruling. And then the Court of Justice has in fact annulled the part of this regulation on the financing of the agricultural policy as regards the publication of information on natural persons. So it doesn't apply to companies, but it applies to natural persons. So the Commission now has to propose a new regulation which would take into account the judgment of the court. This another judgment related to the interaction between transparency and personal data protection. And the last strand of this initiative was a review of Regulation 1049 of 2001. I will come back to that in a minute. Globally, the main effort has been to put more transparency on the way in which the Commission elaborates new policies. As you know, the Commission doesn't decide, it's not a legislator, it is an initiator of legislation. It is the Council of the Parliament that in fact are the legislators in the EU. The Commission takes some measures, but only on implementing measures, and now also, since Lisbon, on delegated powers. But principally, the main task of the Commission is to propose new policies to the legislator. So we have now information on lobbying. There is also a new register on expert groups, because the Commission is also assisted with a number of expert groups. So there is now a register with all the expert groups, about just under 1,000 groups, with all the names of the experts that have been appointed in these groups. And then there is a website for public consultation, in where anybody can either react to public consultation and also see all the contributions, because in principle, every contribution made by members of civil society to consultations are now publicly accessible. Regarding decision making, the process of lawmaking is now also traced back in different databases. There is a database in which all the Commission proposals are introduced, with all the different steps through the Parliament and the Council until decision making. The whole body of EU law, of course, is also accessible online, and then there was a specific database concerning the so-called comitology decisions, the decisions taken by the Commission on implementing powers, where the Commission has to decide, but has to consult a committee of experts of member states. And there is now a specific register with all these committees are listed, and also their agendas, the records of their meetings, and also the measures proposed to the Commission. This has been evolving in the last 20 years, and now we have Lisbon. And in fact, what the Treaty of Lisbon has done is provide a legal basis for much of these things. There are basically two articles in the treaties after Lisbon. It is Article 11 of the Treaty on European Union, which is the more general treaty, which in fact provides a legal basis now for the dialogue between the Commission, the institutions, and civil society. I have given a handout of this to the organizers, and I've reproduced the relevant text, so you will receive a paper with the different text. So this article concerns basically the open dialogue between the institutions and civil society, and it also, there was a specific provision on the citizens' initiative, which is something completely new, where now 1 million citizens in 7 EU member states can take an initiative and request the institutions to take action, and then the Commission will have to say whether or not it will take this initiative and propose legislation on the basis of this initiative. The other article is Article 15 of the Treaty on the Function of the European Union, which is the treaty that is the renamed EC Treaty, which is now called TFEU, where you have different principles. It's the fact that the Council will now have to meet in public when it legislates, and also the right of access to documents, which already existed under the Amsterdam Treaty, but now Lisbon has expanded this to all institutions, bodies, offices and agencies of the EU, whereas under Amsterdam it was only in principle Parliament, Council and Commission were covered. So I will now briefly come back to the legal framework of the regulation and the way in which it is applied in the Commission. As regards the institutions covered, in a way, Lisbon has been anticipated, because even if the regulation only applies to Parliament, Council and Commission, it has been made applicable through secondary legislation to all the agencies, which are these kind of semi-autonomous bodies implementing EU policies. The European Economic and Social Committee, the Committee of the Regions, have adopted these rules on a voluntary basis. And then the Court of Auditors, the European Central Bank and the European Investment Bank have also rules which are not exactly the same but very similar to the regulation. So in practice, most institutions apply this regulation, the big exception being the Court of Justice for the moment. As regards the who has access and to what, the scope of the regulation, first of all, is all documents in the possession of an institution, either drafted by the institution itself or received by it. So it also covers third-party documents, as was been mentioned by Bart. And the definition of document is very wide. It's any content, whatever its medium. So it can be a document, it can be an electronic document, it can be an audio tape, it can be a video recording, it can be anything, any information which is kept on a medium is a document. Who benefits from the regulation? In principle, it's EU citizens or residents, but in fact, the Council, the Commission, and the Parliament have extended it to any natural legal person. Bart also mentioned the Aarhus regulation, so which is there is a specific regulation which applies the principles of this Convention of Aarhus to the EU institutions. The Convention is about access to information, public participation, decision making, and access to justice in environmental matters. So we have a regulation, 1367/2006, which applies this to the institutions, and there is an interference with the access to documents as regards access to environmental information. So, in fact, the regulation refers to Regulation 10049 for the procedures, for the way in implementing it. The only thing is it creates an automatic overriding public interest in disclosure when the information concerned is about emissions into the environment. This is an automatic override. And it sets out an additional exception in order to protect the environment, and in particular the breeding places of rare species, which is something which comes directly from the Convention of Aarhus.